Good evening. This is Rahul Reddy. We're live here every Tuesday from 5 p.m. to 6 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
We're going to talk about marijuana today. Very exciting. What is our advice on that to people, and what are the consequences of marijuana use? We're also going to talk about what we're seeing happening for people who have filed H-1B petitions and registrations in the lottery with these fake companies that are saying they're going to do this in-house project. What are the kinds of documents these companies are submitting to get these approvals, and then what's happening after to the individuals who are stuck dealing with these companies, even after they've moved on to new companies. We'll talk about converting to H-1B as we're coming up with the lottery for next year. People may be considering, do I file a change of status if I'm in the US and some other status, or should I do consular processing? What are the pros and cons of those? And of course, we're continuing to hear news of layoffs, particularly in tech, which has a higher percentage of non-immigrants, people on H visas, L visas. How is that impacting you? What are your options? Should you file a change of status to some other status, or should you return to your home country?
Emily, you're saying the title of the heading that you put it is marijuana use is still not legal, period. And you did not leave any room there to establish that is there a debate about it? Because when I went to Portland, Oregon, there are shops of marijuana everywhere. Even Texas also, I see something like CMD, which is actually marijuana is illegal. I don't know what that different marijuana here, different marijuana in Portland and Denver. When I was being told, hotel, they said, do you want marijuana? They'll come and deliver it to me. And the hotel people gave a sheet to me saying, you want marijuana, you can get it. But of course, they told you cannot smoke in the hotel. You can smoke outside. Now you're telling it's illegal. Can you explain what authority do you have? Oh, by the way, there are stocks that are available online where I can buy the stocks. And you're telling it still is illegal.
Right. Yeah, and this is because even though the individual states may have voted to legalize it over the years, the federal government still considers it to be a crime. And particularly for immigration, there is a ground of inadmissibility for controlled substance crimes. And that's exactly what this falls under. So even if what you're doing is completely legal in the state that you happen to be in, for non-immigration purposes, for immigration purposes, it is illegal. Don't do it ever. Don't be around it. Don't have that be part of your job.
Well, you said non-immigrant cannot do it. Then you said immigrants. That means green card holders cannot also do it?
Correct, yeah. Unless you're a citizen, you should not be anywhere near marijuana.
Well, if you're a citizen, please consult somebody else because we are not the lawyers for it. We are only immigration lawyers that deal with non-immigrant visas and green card holders. So if you fall into this category, the use of marijuana, the possession of marijuana is completely illegal. We also suggest that you do not buy any marijuana stock. We also suggest that you do not enter any of the store that is selling marijuana. Why? Because when you enter, they ask you driving license, you scan it, they will register it that you entered there. Now, then it may be your burden to prove to the satisfaction of the immigration officials that you went into that store, you did not buy, you did not consume, you did not trade. It's going to be a big burdensome thing for you to do that thing. I would flatly tell people, just stay away from those stores. Anything that is marijuana stock, even though I see in California, in Portland, the stores are there. They sell marijuana. It's legal. You can come in our store. They will advertise that thing. Don't believe that stuff. When it comes to the immigration, it is considered to be a controlled substance. That means that if you ever use those things, you will fall into the controlled substance. It is an exclusion grounds. That means that you cannot enter back into the United States. There are instances their passport visa has been revoked. There are instances where people have got into trouble when they went for citizenship. There were many instances. So stay away from those things. Even though in some states they may say it's legal, stay away from those things. Emily, what if I just what is just I consume it, and you know, and I never been caught for it. Can it be still be there?
Yes, it's still a problem because even if you're not convicted of marijuana use or use of a controlled substance, if you admit to the crime, even if you're not convicted of the crime or the charges are dropped,
Or never been filed,
Or
because
never
in
even filed, 'cause it's
states like
legal.
Washington, Colorado, and Oregon, they won't even file any charges. So is it still a crime?
still a crime in terms of immigration, still makes you inadmissible. And you know, the waivers for that are quite limited. They're very specific. So you definitely don't want to get into that situation.
And what waivers are available in Leaf?
So
For
for
marijuana.
non-immigrants, there's a basic waiver that covers pretty much any ground of inadmissibility. We refer to it as a HRANCA waiver, but it basically, you have to show that how long ago it happened and the seriousness of it is one factor they consider. The reason that you're now wanting to come into the U.S. and whether there's any positive or negative effect on the U.S. if you were to be let into the country. So those are the factors they're going to look for to determine whether you may qualify for a non-immigrant waiver.
And how long does it take? Is it like I just go and apply and they give the waiver?
No, so it's going to be a very long process. You know, at least 150 days is what is their standard processing time for waivers, but they go normally beyond that. So I would plan on a year or two wait. And this is assuming it's just admitting to or a conviction, not assuming there's any kind of DUI involving the situation. So if you have a DUI on top of it, then you're looking at the health ground of it inadmissibility, the mental health ground. You also have to go through a medical panel physician to make sure you're not a drug abuser on top of it. So definitely stay away from that. On the immigrant side, if you're trying to apply for your green card, you basically need to have a qualifying relative, either a U.S. citizen or green card holder who's a spouse or parent who would suffer extreme hardship if you were not allowed to receive your green card and stay in the U.S. It's very difficult for a lot of our clients. They don't have a U.S. citizen spouse or a U.S. citizen parent or LPR spouse or parent. Kids don't count for that. Now, the other way to get a waiver for the green card is if the crime happened more than 15 years ago and it was just one instance and it was a small amount, then you could potentially get a waiver without needing that qualifying relative. But there are very specific guidelines there. And again, you've got to wait 15 years before you can even think about it.
Really, you want to do all these things, guys? Come on, stay away from it. That's a better way. You want it? Go have a Scotch legal one. And, of course, don't drink and drive. For sure. Emily, I'm getting a lot of consultations, and we do have a free Zoom conference calls every single day in our office, which we've been conducting from past 10 years, from 2002 onwards to right now, where I get these people from India coming to my Zoom call, and they say that they have paid money to some of these consultants to file the H-1B. Their H-1B got approved, and the consulate is issuing a 221G and going for an interview and getting the rejection. Have you seen these kind of things very commonly? And what's the solution? How do you inform our audiences? What should they look into when they're filing for H-1B?
Yeah, number one, stay away from this situation. So if the company is asking you to pay money in order for them to register you in the lottery or in order for them to file the petition on your behalf, you need to stay away from that. If the company is, if you don't know of the company, it's a brand new company, they have no employees, no one you know works for them, has actually worked for them, be very skeptical of that. If they're saying that, they'll just say that there's an in-house project you can work on and they'll find an actual client project for you later, be very skeptical of that. These companies are, once it's time to file the petition, or even before that, when they're registering, they'll have 5 of their sister companies registering for the same 50 people. And USCIS can easily match the data on that and see that the same 5 companies are registering the same 50 people. And that's 250 fake registrations based on just one company. And this is happening again and again and again. And then when
same guy, Emily, what he's doing is that he's opening companies in 5 different names, maybe his cousins, probably whoever it is. And then let's say he has a pool of 50 people that want to apply green H-1B from India who are willing to pay him the money. So he's applying with 5 different companies, whichever comes in the lottery. He takes the money, files the H-1B. The bad thing is USCIS approves the H-1B for these people, only to be rejected in the consulate later on, or probably persecute this guy at a later date. My question is that these 50 people fall into victims, they don't understand it. Sometimes they even come into the United States and then they promote these kind of companies. And couple of main things when you guys file H-1B with any company that you need to look into. First, look into their website to see the address. Is the address a genuine address? I mean, recently I have some inquiries today, I had some consultations today where the company filed H-1B from a home address and they filed 40 H-1Bs from the home address. Cummins, Georgia. That seems to be very commonly ringing the bell to me. And then they put an end client, which is also in Georgia. And when I looked into the end client, the end client is also a consulting company. And that end client has given this company as an end client. This company has given that company as an end client.
So they're giving each other end client letters.
And not only that, the second company was actually in the condominium. The first one was a house. Second was a condominium. So when you look into these companies' website, first try to Google map and look into what is the address. Is it a house? Come on. People cannot just come in-house project and work in a house. And that to 30 people or 50 people. So that's number one signal. Now, if it's an office, which then you need to also look into, is it a PO box offices? What are PO box offices? There are some companies called Regas. They provide shared offices. So you can go to them and just rent a box, which is $100 or $150 per month. You just collect the mail there, but your office address shows there. So when you Google that address though, check if that's a Regas office. How many other companies are using the same address? For example, if there are 100 companies using the same address, it probably looks like a duck, walks like a duck. It's probably a duck. That's a fraud thing. How can I have 100 companies in one suite number called suite number 300? I mean, it must be a PO box there. So you must get a general idea of those things. And if a company is filing a H-1B for you in the month of March, and they are willing to wait for you until October, now it has to raise a bell to you that, hey, why are they willing to wait for me until October? Now, of course, there are some companies, I don't mind naming them, and that are like Tata, Cognizant, and Wipro and certain other companies. They already have the projects. Let's say, for example, Tata company has a project with AT&T, and they are bringing the individuals from India. Yes, Tata company will be waiting for that. Cognizant will be waiting for that. Absolutely, they'll be waiting for you. But this small company called ABC Consulting Inc. from Cummins, Georgia, from a house, telling that they have an end client, which probably is a consulting company too, and they are willing to wait for you for 6 months period, that should ring a bell for you. Anything else, Emily?
Yeah, so again, definitely stay away from those companies if you are looking towards H-1B in the future. But if you've already had this situation, we're seeing site visits happening, and then when the individual travels or goes to the consulate, they're being interviewed, then they're getting a 221G, and you're just stuck there at that point. What options do they have?
First thing is that if you find out that your company is a fraudulent company, just withdraw your visa application. You don't want any bad mark on you though. That's the first thing I would do, Emily. Just back off from the company, don't go with the H-1B. The second thing is that, which I want to do, is that get your money ASAP. Why? Why can't you wait and get it? The reason is that if there are 50 people that they have handled, okay, and of course, all these people are going to fall down, they're going to try to get the money. Whoever gets the money first will get it. That's one possibility. There is a very good possibility that this particular employer will run away. And what I would do, what I would tell my client is, before driving the entire company to the death, which happens most of the time, if not all the times, I try to tell the guy, collect your money first, as much as possible from this guy. Let him go to death. Who cares? Whether the company dies, whether the guy goes to jail, which he deserves to go to jail. So threaten that guy, with a form called WH4. Even if you're in India, you can file this form called WH4. It's Department of Labor. You will Google it, Department of Labor, WH4 form. What I would do is fill the form out. Don't submit it to the Department of Labor. Why? Because once you submit to the Department of Labor will conduct a formal inquiry and they will try to get the money for every employee whom they took the money from. Now, before everybody gets it, I would like my client or the people who are listening to this conversation should get their money first, because I would normally threaten the employer, hey, you should threaten the employer, give my money, okay? And if he doesn't, go and file with the Department of Labor. Department of Labor will get the money though. So that's very crucial to try to get the money as soon as possible from this company though. It's called WH4, Department of Labor. Anything else?
And does our office help with those kind of situations?
Yeah, if you have paid the money to these companies, you got cheated by these companies, please contact us. Of course, we'll take a percentage of it. But yeah, we will contact the company and try to get the money. But of course, no assurances, because these companies will close, they will run away, they will go to jail, and we may not be able to collect the money. That may happen. But we'll try to collect the money. That's a best score. That's a best course. Yeah, contact us if you have been cheated by these companies where you got affected. You paid the money. A lot of questions come in, Emily. Oh, I paid the money to the cousin of that guy in India. Can you get the money? Yes, you can get the money. The reason is that when you file the WH4 form, the Department of Labor is going to contact every employee to check to see if any of them have paid the money, which we know what happened. So when they call these people up and everybody says this cousin, that is considered as a money laundering. And this guy can go to jail easily, very easily. So you may want to contact a lawyer to collect your money. Not just the money, I would try to get more penalization for the sufferings that you have gone through with this company.
All right, next up we wanted to talk about coming up in the lottery. If you are in the U.S., you may be able to file a change of status to H-1B if you're selected in the lottery. When is that the right thing to do? When should you request consular processing? Is one option better than the other? So what are the basics of how do you qualify to do a change of status?
For you to apply for a change of status, you must be in United States. You must maintain a non-immigrant status. For example, you must be an F1 visa, H4 or L1, similar kind of those kind of visas. Emily, some of the reason I want to point out this is that some of the companies are choosing to file consular processing from F1 visa, and they are giving the students an option saying, hey, if you are on F1 visa, you do not pay the Social Security taxes. So you're going to save that money. But if you get the H1B, you're going to pay the Social Security taxes. But what is a loss in the students for them, Emily, if they just not apply for change of status? And they're telling that, hey, you can get the H1B stamping within the 3 years that is left over at any point of time. Is that how you suggest it?
It definitely sounds good on paper, but you have to think of long term. What happens if I lose this job? And now I have an H-1B consular processing approval, which means I have not actually been admitted to the U.S. in H-1B status. I can't get the visa now because I don't have the job anymore. That means you're not actually counted in the lottery.
Can I not transfer this one to a different company?
No. The only time you can transfer is if you've actually gotten the change of status or you've gotten the visa stamp. So of course, if you've gotten the visa stamp, that means you still have that job and you are fine. But we can't predict the future. So there's lots of things that can go wrong in the employment situation. So I generally tell my clients, yes, you might be foregoing 2 years of STEM OPT, or you might be having to pay the Social Security taxes instead of not paying them. But the benefit is you get the H-1B locked in. You don't have to go through the lottery again.
And this is actually going to benefit the companies that are advocating it more than to you, though. As an individual, though, I know you came from the country, you completed your degree, you're here in United States, you want to get H-1B, you want to get in the path. Now, a little bit of that 6% or 7% won't make much difference, believe me. Speak with any 40-year-old guy who's been in this country for 15 years plus, okay? They are all millionaires, okay? Most of these people are. So why are you trying to save this penny and losing the millions that you may be entitled for? You'll be risking it. Now, for the company though, they may be making, like if there are 100 employees, they may be making a lot of money on that one though. Okay, that's a lot of money for those people though. So at the cost of your visa, at the cost of your H-1B, you're going to benefit them. Believe me, it's not worth for you to save that money. Now, it's not that I never tell people to save the money. I'm very good advisor to telling the people to invest in 401k and whatever not though. But when it comes to the visa, when you want to risk your visa for saving a little bit of that, it is definitely not worth. What is that? Save the penny, lose a million. What was that word? I can't forget.
Yeah, I can't
Yeah, it's like you're saving penny to lose a million. It's definitely not worth change of status. As Emily has pointed out, if the H-1B is approved, you're still not counted toward the H-1B. You can't change the company. And if your project is over, you cannot go for stamping. And even if the project is there, if you're going after 2.5 years, the counselor doesn't like you coming at that point of time there. So these are all minus points going against you. Please recommend strongly for your company to only apply change of status. If they are not willing to, you may want to consider. Actually, if you have an option to choose a different company where the job is there for you to actually go with that company rather than staying with that company, because they are not working for your benefit.
All right. Now, not everyone is going to have the option of a change of status. If there's anything in your F1 time or your prior status where maybe you exceeded the unemployment limit or you're not properly maintaining your F1 status, or maybe you attended one of these day one CPT schools or something like that, those situations you may need to consider consular processing. But for your basic person who's on F1 in their OPT, no issues of status, we almost always automatically file that as a change of status unless we know that the person has travel plans to where they would abandon it by leaving while it's pending.
Emily, now the layoffs are happening. We see in a lot of technology companies, layoffs are happening. This is not the first time. We have seen that in 2000. We have seen that in 2008 and 2009. Now we're in 2022. Our stock market is nosediving and we see the layoffs. Now, everybody knows that the 60-day option is there if the I-94 validity is still there. So for example, if the H-1B is valid until 2023, December, and they get laid off, the 60-day period is there. Everybody's aware of. Now, when does the 60-day period start? For example, if I get laid off with Twitter on November 4th of 2022, I am getting the paycheck until January 4th of 2022. When does the 60-day period start? Does it start on November 4th or January 4th?
There are multiple interpretations of this, and it's because there's not clear guidance from the Immigration Service. What they refer to as a cessation of employment. What exactly does that mean? If you're still getting paid, have you actually stopped your employment? I think the safer way to interpret it is that from the day you actually stopped working, that starts your 60-day grace period, even though you're continuing to be paid, especially with these high-profile layoffs where it's in the press exactly when it's happening. USCIS, they don't live under a rock. Those officers may be familiar with what's going on. And so if they're going to see a H-1B transfer happening in February for someone that worked for one of these companies that was doing layoffs in November, they could potentially question that. There are arguments that can be made that the employment relationship continued and that the 60-day grace period shouldn't start until the actual pay stops. But at the same time, you don't want to get into that situation where that becomes a question if you can avoid it. And one way you can avoid it is by, as a backup plan, let's go based on the 60 days starting from the time you stopped working, because they could also say that by not working, you're not maintaining your status because you're not working under the terms and conditions of your H-1B. So let's start from the time you actually stopped working and count 60 days. And as a backup plan, you could file a change of status to an H-4 if you have a spouse who's on H-1B. You could file a change of status to B-2 to buy yourself some extra time while you're continuing to look. That way, if you do later file a transfer and the argument that the 60-day grace period extended longer fails, you've at least got that pending application that keeps you in a period of authorized stay until you can get a visa appointment and get back to H-1B status.
Emily, a couple of questions that I have is, if I change the status to B2 or if I apply for F1 visa though, and now it's been, let's say I got laid off on November 4th and I am in May of 2023, my B2 or F1 is still pending. Can I apply change of status from B2 or F1 to H1 status? Will that change of status will be approved?
You can file it, but it won't be approved because you're not maintaining any status at the time of filing.
So
Having that pending application is not status, it's authorized stay, which sounds the same, but they're actually different. And so you can't change status unless you're actually in status.
Okay.
But the thing that you can do, assuming that you have a valid visa stamp that's unexpired from your old job, you could have the new employer file the H-1B petition requesting consular processing. And as soon as you get it approved, because you have the valid visa stamp, you just take a quick trip to Canada or Mexico and come right back in on the old employer's visa stamp and the new employer's consular processing approval, and you're back in H-1B status. And there's never a question raised about when the grace period actually started or ended.
Okay, let's go to questions, Emily. Now, I'm getting a lot of questions with regards to the EAGLE Act. Is the EAGLE Act dead? Well, not yet, but there seems to be not a very high hope at this point of time, but I still want to fight it out right now. We still recommend people to write letters to the congressman. We still have about maybe a week left or so for it to be passed. And this week, is Christmas and all those other things. So it's about 7 or 8 days left. I still recommend people try to get this one passed, though. We will tell the solution if it's not passed, what should be. At that point of time, we may recommend not to go to the Congress because that's not working out. We may want to recommend to go not counting the family members, using the unused green cards. That may be a better solution. But that's not the proper solution right now. I'll wait for a week or 10 days to see how the things are going on, and then we'll make a decision which way to go. For now, it's not dead. It's still alive. You never know. It might just sneak out and get it approved. Joe Lufkin is trying to do everything. However, we have not seen a bipartisan support as much as it was 2 years ago when Trump was in power. We don't see the bipartisan effort at this point of time. So even if it passes in the House, we don't know how it's going to face in the Senate. Still hopeful, but keep fighting for it until January 3rd, and after that, we'll see what other options we have.
Santosh has the H-4 EAD application in the C-26 category and filed the renewal also in the C-26 category, but when he got the EAD card, it says C-9 as the category by mistake and wants to know what he should do. So we are seeing this from time to time. It's not anything that's on fire that you have to get it fixed immediately. I do recommend getting it fixed at some point because when it's time for your next extension, an employer is going to be looking at the category that's on your card and the category that's on your receipt notice to make sure they're the same to see that you qualify for any automatic extension that might be available. You also want to time fixing this carefully. If you're in the middle of looking for a new job and you have to send in this card because to get the new card without the error, you're not going to be able to complete the I-9 until you have the new card in your hand. So if you're in the middle of a job search, I might suggest hold on, get the job, complete the I-9, and then you can go through the process of getting the card replaced with the correct information.
Jyotirmai has this question. If I change the citizenship will it cause any problem for the H-1B or I-140, which I already have it? No, you're fine. You will still be having counted toward the H-1B number. Your I-140 priority date will still continue. However, for the category for which, the immigrant category for which you're going to coming in, Would you be considered as a different country national? Unfortunately, not. You will not be considered as a different country national. Emily, previously we said that people are eligible for e-visa if they buy a citizenship from some country. I'm not speaking of illegally buying, guys. You can legally buy citizenship of countries. Really? Is there any change on that?
Yeah, so with the passage of the NDAA, they did include provisions related to e-visas, and one of those provisions is if you are acquiring the citizenship of another country that allows it to be acquired by money, by investing in that country, now you have to actually become a resident of that country for at least 3 years before you're able to use that citizenship for purposes of obtaining the e-visa. So keep that in mind. That's a very recent change. If you are thinking of using investment as a way to change your citizenship to be able to get an e-visa, that may be more difficult going forward.
Government officials, please stop watching our YouTube. Priya has went to the government center in 2020 to buy a gummy. She showed her ID. I definitely recommend Priya to contact an immigration lawyer. Because when you go into these centers, though, they scan these IDs, and these stupid people are sending that information to the federal government. I don't know why they are doing it, but they are doing it. And that's the reason why we are telling other people, don't go to these places, guys. We are speaking about the marijuana places. Don't go to those places because they are scanning. Now imagine this, when you go and buy something in Walgreens, Walmart, do they scan your ID? They don't. They don't. They don't ask your ID. At the most, when you buy alcohol, they do ask your ID. Of course, they do ask the ID. Nothing wrong with it, but of course, you must be 21 and above and don't drink and drive, but it's completely legal to buy alcohol, but not legal to buy marijuana for the immigration purposes.
Mike has a priority dated 2017 in the EB3 category, but has 2 U.S. citizen kids who are 8 and 9, and wants to know, what is the possible opportunity to get the green card? Is there any way to expedite the process? So under the current law, unless Congress changes something or unless the Biden administration reinterprets something to stop counting the dependents or recapture green cards, you may have the fastest option of getting the green card through your U.S. citizen kids. The oldest one, 12 years from now, when they turn 21, they would be eligible to sponsor you as an immediate relative. That may be faster than the EB3 wait time for a 2017 priority date, which is ridiculous to say, but that is where we're headed.
Simple question that comes is a joke that Emily. What if the 21-year-old kid says, I'm not going to sponsor you? That's a joke, guys. Sanjay Verma has a very good question that this comes out very often. In fact, there's only one article written on that, and it happens to be me who wrote the article on it. I am an Indian national. I'm likely to remain on H-1B until I retire. In that scenario, will I get the Social Security retirement benefit? Yes, you will. To get the Social Security benefit, you don't have to be a US citizen. You don't have to be a green card holder. As long as you reach the maturity age, assuming that you already contributed 40 quarters. That's what they call 40 quarters. That means practically 10 years. If you work in the United States, that will be constituting as 40 quarters. 10 years is 40 quarters. So if you work for 10 years and you have paid the Social Security, now, in that 10 years though, any F1, OPT STEM extension, because at that period of time, you're not paying the Social Security taxes. Only H1B period will be counted towards it, not the OPT and STEM extension, unless you have paid Social Security, which you normally don't at that period of time. So the 10 years of H1B period will be, and you can go to India and you can apply for Social Security if you reach the maturity age, and you can derive the benefits of it. There's an article on Reddy and Neumann RN Law Group website. You can read that article.
Chandrasekhar received his green card recently, but his daughter's green card is still pending, and he wants to know if he can raise an ombudsman request to get his daughter's green card. So number one, you'd want to look at, is the priority date still current? So if your date went backwards to where your date is no longer current, there's nothing that can be done because you need to wait until the date becomes current again in order for your daughter to qualify. But assuming the date is current, Ombudsman is generally not helping with these situations anymore. They're getting so many requests from different issues that are happening. There are so many broken things in immigration that they are really focusing on true life or death situations, situations where there's a deadline and you didn't get a notice on time or something like that, travel situations. So typically the Ombudsman is not right now able to help with that situation. If the date is current, litigation may be your next option. Social media, similar situation. 485 has been pending for more than 19 months. Got an RFE from the Tampa field office in June, already responded it until August, and then nothing, any suggestions. So again, assuming that your date continues to be current, litigation at this point is your best bet. Our office is filing those. They are working. You can reach out to Stephen Brown in our office for more information on that.
Questions that come from ST. My priority date is not current, and the 485 is in the process. And if I get laid off, what are the options? There are different options available. We discussed it in a couple of our videos before. If the adjustment of status is pending, and if you get laid off, what are the options? You may want to watch that. I think so. We did it about 2 or 3 weeks ago on the Tuesday session. One thing is that you need to contact an immigration lawyer immediately. Getting laid off is not that adverse, but you must have a job offer open for you continuously, though. And you may be tested by the USCIS official if you have a genuine job offer, though. I would recommend to find another job as soon as possible. If that's not possible, though, maybe your wife can open a company. If that doesn't work out, your wife doesn't like you anymore because you lost the job, you can open your own company. Now, your wife employing you, or you self-employed, there is a clear memo from USCIS. You can self-employ yourself too when you are in adjustment of status. However, we recommend to stay away from it unless you have no options left. Instead of being unemployed, no offer, I would rather self-employ myself. That's a better defense when you go in front of the USCIS official. But of course, if you have another job offer for you, that will be much better rather than self-employed. But contacting lawyer is very important for you, because I'm more interested in getting you the green card. I'm not that interested in saving that much money for you.
Dinesh had the priority date current under EB3, but had filed the 485J supplement to upgrade to EB2 back when USCIS was telling everyone to do that. And he has confirmed that USCIS has put his application in EB2 according to a congressional inquiry. Now he wants to know what are the options to go back to EB3. So you do have the ability to transfer the underlying basis multiple times between EB1, EB2, and EB3. So you could do another transfer of underlying basis back to EB3. As of this moment, it's still using the supplement J. So you can have the employer sign another supplement J, this time referring to the EB3. The supplement J filing address for this purpose did change recently. There should be an article on rnlawgroup.com. I wrote it within the last month, talking about going from EB2 to EB3 back to EB2, or the other way around. So you can find that. It may take multiple contacts, multiple follow-ups. You might have to work with your congressman on it. There's no great system for it right now because there's not really any urgency now that we have fewer green cards for this year.
Amit Kumar has this question that his wife's H4 EAD is expiring in December 31st of 2020. Should she go on a leave of absence, or should she resign from the company? Well, I have a better option though. There is a video we made about 6-7 months ago. Google it, with 540 days H4 EAD extension by going to Mexico. But she needs to make the trip to go to Mexico and come back before December 31st of 2022. And you may ask a question. She doesn't have the visa stamping to come back into the United States. Yes, there is something called automatic revalidation. That's the reason why we are telling to go to Mexico to come back though. Now for those things, you definitely need, your H1B must have already been approved. And she's making this trip before coming back, before December 31st of 2022. And if you could not still understand based on that video, you can always consult us and I will explain you how that things can work out.
Amit has a spouse who's on H4 EAD that's expiring at the end of the month, and he wants to know if she can go on unpaid leave to wait for the new H4 EAD approval, or if she needs to actually resign from the company. So this is a gray area. What does it mean if you don't have employment authorization? Is it okay to just stop working, but to still be considered an employee of the company? Or do you have to be completely unemployed, no employer-employee relationship with the company? There's no right answer to that. So it ultimately usually boils down to how the company treats that situation. There are many companies that will put the person on unpaid leave and then bring them back when the new EAD comes in. There are other companies that are much more conservative and will actually require termination and then rehiring once the EAD comes in. But from the employee's standpoint, either option is fine. It's going to be up to what the company wants to do.
So Hamid, while filing a DS-160, do we need to use the H4 extension 797 number or principal applicant 797 number? If the H4 extension is already approved, you definitely can use the 797. If the H4 extension is still pending and the H1 is approved, you can use the H1. Either way, it is not going to make any difference. But the H1 must have been approved for them to be eligible to use that I-797 number.
Manoj has an AOS pending in the EB2 category with a priority date that is no longer current, but it is current in EB3. So he's planning on downgrading to EB3. He's got both the EAD and AP approved based on the EB2, but his wife's is still pending and wants to know what happens with the downgrade, what happens to the approved EAD and AP, what happens to the wife's pending application. So basically, if you've got two separate 485 applications, the first EAD and AP remains valid. You can file a second EAD AP. USCIS often approves them. Sometimes they'll say, you already have this benefit, you're not going to get a second one right now. For your wife, they'll continue to process the existing EAD and AP, and she can file a second one. We went through this a lot going from EB3 to EB2 over the last 2 years, so you're basically in the same boat, just going the opposite direction.
AVS Abbas asks a little bit confusing question with regards to immediate relative of an American citizen. He's asking, since I'm above 21, am I still considered to be immediate relative? I'm assuming that by the time the I-130 has been filed, you're already above 21. If that is the case, you're telling you're above 21, but I don't know if you're above 21 at the time of filing an I-130 application. At the time of filing an I-130 application, if you are above 21, you are not considered to be an immediate relative. Now, I know the definition in the grammar may be different, but when it comes to the law, though, most of the words we use it, we define it in the beginning of the law itself. What is an immediate relative? Now, immediate relatives means under 21, unmarried, both have to be there. So if you already turned 21, by the time I-130 has been filed, you are no longer immediate relative. You come under the first preference, assuming you're not married. Now, if by the time I-130 has been filed, you were under 21, I would recommend to contact a lawyer in that case, because it's considered, you could be saved under CSPA, Child Service Protection Act. You could be saved under that. But if you're already 21, by the time they filed I-130, you're out. Filed, not approved.
Paul says his title was not listed as a manager in India. It was senior lead engineer, but he did manage 10 to 12 people and then transferred to the US with the title as a manager and has people reporting to him here and wants to know if he's eligible for EB1. So this would be EB1C. So it's not the title that controls. So even if you were a senior lead engineer in India, if you were actually performing duties that showed your managerial capacity the majority of the time, you can qualify for EB1C. So what they're going to look at is your actual job duties. They want to see what percentage of your time you are spending actually directing your direct reports, telling them what to do, giving them feedback, doing performance reviews, what kind of authority you had over them. And so if you meet all of those requirements, even though manager isn't mentioned in your title, you can still qualify as a manager for EB1 or L1A.
Madan has this question. His prior date is current. It's been 20 days since it's been current in December month. Still no action. How to exploit it? The main question, Madhu, is that when did you file the 485? If you have filed the 485 more than 1 year ago, I definitely recommend to sue the USCIS under writ of mandamus. But if you have just filed the 485 in the month of November and it's current in December, you expect the green card, they may not give you in December. But if you have filed more than 1 year ago and it's still current, you may definitely want to consider suing the USCIS. Any updates from the visa recapturing bill? Nothing is going. That visa recapture bill is not going to go through this Congress, and I do not expect any of that sort coming until probably December of 2024. Then we will see at that point of time, but nothing is hitting this Congress. Now, there may be a lot of proposals of the bills. These congressmen just propose it. It doesn't mean that it has a possibility of passing. At this point of time, the only serious thing is the EAGLE Act, taking the per country limit off, protecting the children who are under 21, allowing the people whose I-140 has been filed more than 2 years ago to file the 485 application. That is the only serious thing right now. There may be a lot of proposals in immigration. There are like 150 bills that are pending. We don't give it very serious consideration unless we know that these have higher chances of getting passed.
Maddie wants to know if I use my C9 EAD, that's the one related to the green card, to get my driver's license renewed or to use it for identification purposes, but not using it for work and not using it to travel with the advanced parole, am I considered to be using EAD? Would it end my non-immigrant status and make me rely on the pending 485? No, so just using that EAD for purposes of driver's license does not mean you are relying on the EAD for your immigration status. It does not have any impact on your non-immigrant status. You're not pending 485 status.
Kellogg's fan from YouTube has this question. Although Immigration Nationality Act tells you that you have to carry the green card everywhere, I'm very afraid to lose it or misplace. Can I just carry a scan photo of GC on my phone and my driving license? Kellogg, here is the thing. When I was a green card holder, I did not carry my green card wherever I go, except when I was traveling outside the country or when I'm going to the border towns. What does border town means? I'll tell you an example of it. If you go to South Padre Island, there will be some immigration checkpoints. There are really immigration checkpoints. I've personally been there, especially to Big Bend and some other places. There'll be immigration. If I'm planning to go there, at that point of time, I used to carry the green card. But I'm in Houston. Let's say, for example, if I want to go to Dallas, if I want to go to San Antonio, if I want to go to Austin, I never used to carry the green card. I am not telling you what to do. And you already said, what does the INS say? I'm just telling what I did. You take it what you want to do from that.
Chirag wants to say, has applied for the 485 in EB2, but the priority date retrogressed. He wants to know if he can go back to India and live there until his date becomes current again, and then come back once it becomes current. So there's going to be some problems with that. Number one, you have to have the valid job offer. So the employer has to be willing to hold that job open for you while you're gone. But the bigger issue is you have to have a valid advance parole or be going and coming on the valid H-1B to avoid abandoning your 485. So if you have an advance parole and you leave and then your advance parole expires because you're staying outside the U.S., you have no way to come back and you've abandoned your 485. So not a good long-term option, but you could convert your green card to consular processing and just finish the process at the consulate when the date becomes current. It does require your employer to file another application, an I-824, to notify the consulate that your I-140 has been approved and that you are now pursuing consular processing rather than adjustment of status?
I'm an H1B. I am an H1B, but also has a GCEAD. If I want to work for a second job, do I need to provide my EAD card, or should I just provide a social security number is enough? Your new employer will ask for an EAD card because your social security card tells that it requires that you must have an employment authorization from USCIS. So you have to give an EAD to them to do the second job.
And Josh says, I have an H-1 approved for consular processing with an employer, and I'm currently in the U.S. on H-4 EAD with that same employer. Wants to know, will my H-1B be revoked if I change employers and file an amendment? So you can't, there's nothing to amend with a new employer, so I'm a little confused on that. But as I mentioned earlier, if you have a consular processing H-1B approval, you're not considered counted in the cap to transfer to another employer unless you have actually gotten the visa stamp and or entered the U.S. in H-1B status. Now, sometimes some people can sneak through and file a new H-1B with a different employer, or a change of status to H-1B with a different employer based on a consular processing approval, but it's very hit or miss, and most of the time those are getting denied, saying you have not been counted in the cap yet because you didn't get the change of status or you didn't actually get the visa stamp.
America Venkat, can we include children who is on F1 under 21 years when filing an I-140? Yeah, in the I-140, they'll ask you how many children that you have. You should list them, and if they're under 21, you should definitely list them. And if the priority date is current, though, and you want to file the 485 application, does the children need to be on a dependent visa on you, like for example, H4, L2? No. Even if they are an F1 visa, if they are under 21, or there's also a Child Service Protection Act under 21, it's a different age under 21, the way it's calculated. If they are under 21, you can include, even if they're in F1, you can still include them and file in the adjustment of status if they are in United States. Now, if they're not in United States, I definitely recommend to contact a lawyer. But if they are in USA, if they are under 21, even if they are an F1, you will include them in filing the 485 application.
Santosh is currently working for company B and filed the green card through his previous employer A and has the EAD and AP, and wants to know, do I have to join that previous employer? Can I travel outside the U.S. without joining that previous employer? So remember, the whole 485, the labor certification, I-140 is all based on a job offer, not necessarily actual employment. So as long as employer A continues to offer you that job and you continue to intend to take that job offer when you get your green card, the process is fine. You're following all of the requirements. There's no requirement that you have to join that company that sponsored you until you actually get your green card. And again, you have to intend to join them. So yes, you can travel without any issues using that AP. It doesn't matter that it was with a company that you're not working for today, because it's based on a job offer of future employment when you get your green card.
Satyam has a follow-up question on that. What about the derivative green card? Well, do they have to, if they change the company after they get the green card? Well, the derivatives have no meaning in this green card, though. They could be working, they could be sitting at home. They could be changing the employer. It won't matter. No. They can flip the burger in McDonald's. They can be a Microsoft CEO. Wow. There are some things they cannot do. Can they be a drug dealer in Colorado State, even though Colorado State is legal? No. They can't do that job. But can they flip a burger in McDonald's? Absolutely. Can they be a Microsoft CEO? Absolutely. They are legal.
Shavu says, when filling out the DS-160, do we need to use the H-4 extension I-797 receipt number or the principal applicant? We already got that one.
A lot of people are asking me to predict the priority date, guys. We are not expecting any great movements in the priority date in the coming months and probably years too. And if I have to tell you that, sometimes it takes decades, 9 years, 8 years to move one single day for the final action date. I'm not telling that it will be the same, but it has historically been that it moved in 2001 and stopped for a long period of time. Then it moved in 2007 and stopped until 2012. It moved in 2012 and stopped until 2020. And from 2020 to 2022, it moved and then it stopped. Now, what is the basis for what we are telling right now? The USCIS has clearly indicated that they have enough number of green card applications to be adjudicated for EB2 for the Indian subcontinent, so India. And they also tell that EB1 will be backlogged. So starting from January of 2023, EB1 for Indian nationals and Chinese nationals are already backlogged. One thing that did happen was that for the rest of the world, they are expecting a backlog to come in. Now, we haven't seen that yet, though, in the rest of the world, a backlog coming in, but we are expecting it. Now, here's the problem why, when the rest of the world backlogs, we may have a greater problem for the Indian nationals. Because the leftovers of the rest of the world, I mean, Indians are guaranteed to get 7%. But anything that is left over by the rest of the world will be given to Indians. But if the rest of the world gets filled out, Indians will only get 7%. And they are telling that the rest of the world will be filled out. That means that Indians will only get 7% out of, right now we have approximately around 200,000 green cards. So only 14,000 green cards will be given. That includes the dependents, that is spouse and children too. So that's going to be very less number coming into the Indian nationals. So it's going to be a lot of backlog. Be prepared for sticking here for a long period of time, because it's not going to come sooner. Have a mentally plan yourself to stick for a long period of time on H1B.
Bill from YouTube wonders if employers are generally agreeing to provide the Supplement J form in the event that you use the GCEAD to start working, or if they are, giving any pause in providing the Supplement J. So we generally see most employers are willing to provide it. Sometimes they might delay providing it and say they'll only provide it in the event of an RFE or if you're called in for an interview. But that's totally fine as long as they're willing to provide it, which most of them have been.
Pavan, EB1 retrogression is disappointing, and can you predict the priority dates going forward? Most probably it may not be current this financial year, which ends in September 30th of 2022. And going further, I don't think so it's going to be current unless the economy dives down like the way it happened in 2008 or 2009. EB1 may not be current for Indian nationals. And we may be expecting the same thing coming for the EB5 also for the Indian nationals. That's something?
I think we are pretty much out of time for today. Thanks so much for joining us. Don't forget that you can always join us on our daily conference call to get your questions asked if you weren't able to ask it today or get your answer today. You can go to rnlawgroup.com to get the schedule for that, and you can also sign up for our newsletter while you're there.
Thank you very much.